His family is very devoted, very supportive. He has a village behind him. I believe his family is here today. They're sitting on the front row. This is not a situation where Mr. Reese will try to abscond or try to evade the jurisdiction. Mr. Reese wants his day in court along with his significant community ties. Mr. Reese is employed. He has a number of occupations. He does community outreach with a nonprofit called Charlotte Hopes Incorporated, where they provide empowerment and encouragement to youth aged 5 to 18 who suffer from mental and physical health issues. Along with that, his family has owned a daycare, learning academy / daycare for the past 5 years, where he works there as well. He has been employed, gainfully employed, since he graduated from Life Christian Academy. Mr. Reese has no felony convictions. He doesn't have a violent criminal history. The present charges that we're here for today, Your Honor, it's still under investigation. There's a lot that is unknown. We established at the prelim that this case is still ongoing. There were multiple shell casings at the scene. No witness can point out my client to be the shooter. There were multiple shooters. It's established that there were multiple shell casings, which, in my conclusion, that there would be multiple shooters. Over 200 people there at that nightclub that night. Multiple people with black hoodies, multiple people, African-American males with dreadlocks and wigs. And that's the description that they give. He doesn't pose any danger to the community. When we're talking about felony, posing a significant risk of committing any felony pending trial, he has no felony criminal convictions. He has mainly driving infractions. He has 2 open cases, which are in Fulton County. We'd like to address the 24 case, which you already know of, theft by receiving and attempting to elude. That case, the facts on that case are, he went to pick up a car for his family member that got stolen, and on the way back, he gets stopped. I have spoken to that family members who car it is, and when we have that prelim, they will be present to address that situation. So he was stopped after picking up a car that was stolen. He found out who had the car, and he went to retrieve that car. The 2022 was
Mr. Connor.
Yes.
Mr. Connor, the potentially more interesting fact about that case, though, is that isn't it currently in judicial hold because there's a failure to appear?
No, that's the 22 case, I believe.
Right.
Right. There's 2 cases, the 24 case and the 22 cases in judicial hold. But I believe that was the 22 case was a notice problem because of an FTA. So I guess they had the wrong address. I don't believe that he was trying to abscond or evade that arrest, but there was simply a notice problem. There's a 2022 Cobb County case that was no prost. I have that for the court today as well. That was the most serious of the cases. Not to say that these cases aren't serious, but that was the most serious of his criminal history. And that case was no prost. Your Honor, he has no desire to communicate, reach out to any witnesses involved in this case. I mean, that can be a condition set forth by the court if that's a problem as far as communicating with anybody in this case. He has no interest in doing that. And
is there any, Mr. Connor, is there any, I don't know anything about the facts of the case as yet because it's new.
Right.
Is there any allegation of a pre-existing, is there any indication that Mr. Reese knew any of the people that were involved in this dispute that resulted in the shooting at the nightclub?
I mean, it's all hearsay, Your Honor. It's the word on the street. There's nothing set in stone, in fact, that Mr. Reese and anybody involved in this case knew each other.
So translating that, it sounds like there might be some discussion of a relationship, but you don't necessarily credit that discussion. Is that right?
Correct, John. Correct.
Okay.
When Mr. Reese found out about, his warrant in regarding this case, He took the necessary protocols and steps to surrender himself. He hired counsel. He cooperated with the detective. We set up a time. He abided by that time, and we surrendered Mr. Reese to the headquarters. If Mr. Reese had any chance of absconding or evading arrest, he would have took that chance. Mr. Reese wants his day in court. And I want to state that America's justice system, Your Honor, is built on the presumption that bail should be granted if any conditions that can be factored, any conditions to ensure the community is safe, the person poses no danger to the community, witnesses will not be intimidated, there will be no obstruction of justice. In this case, Mr. Reese will not commit a felony or any crime while out on bond. Mr. Reese will appear in court, and if we do it the other way, Your Honor, and maintain people and house people, then the presumption of innocence, which our entire standard in Georgia is built on, is gone, because he would be presumed guilty. In Georgia, unlike other states, for the purposes of pretrial bond, the presumption of innocence remains with Mr. Reese, and that's accused of any offense, even a capital offense, during arrest and even during trial. And that, I have the case site for that as well, as Vanderford B. Brand, 126 Georgia. We won't object to any conditions set forth by the court, Your Honor, whether that's home confinement, electronic monitoring, whatever the courts feels sufficient for Mr. Reese. We won't object to it. Lastly, Your Honor, liberty is the norm of our community. And this custodial detention prior to trial, when there are conditions that can be set and can be fashioned, will be against the law. Thank you, Your Honor.
Thank you, Mr. Connor. Mr. Griner?
And good morning, Your Honor.
Good morning.
So in brief outline, what this case involves is back on May 12th of 24, Mother's Day, 2:24 in the morning, at the Elleven45 Lounge, that's located at 2110 Peachtree Road, Atlanta, Georgia, here in Fulton County, that there were a number of individuals at the club at that hour of the evening. There are security or surveillance video showing what occurred, and what is depicted clearly is this defendant entering the club. He is easily identified by his somewhat shorter stature, his hairstyle, the clothing that he was wearing, and then his image, his face. Later on, and he can be seen tracked through the club. Later on, in the investigation of the case, he is further identified in 3 different ways. One is his cell phone record showing him there at the location, there in the area. The second is that the head of the security team there at the club later identified this defendant out of a 6-pack photo lineup. And the third additional way, is that Detective Grimsley of the Atlanta Police Department was able to identify the defendant on the video. So what occurred was that there were essentially 2 very small groups. There is the deceased victim, Nykris Ridley, and one of his friends. There's this defendant and 2 of his friends. And what the security camera shows is that is a very large room with at least 100 people, I'll guess, who were in the room. Deceased victim Nykris Ridley and the defendant in this case, Creighton Reese, in their respective groups approach each other. Almost immediately, there are punches thrown between Mr. Reese and Mr. Ridley and also their friends, but this lasts only about 2 seconds, literally. They break apart, and there is a clear separation between deceased victim Nykris Ridley and this defendant, Karanji Reese. Any self-defense claim that may have existed prior to that is forfeited when the defendant draws a handgun and starts firing. He ends up shooting 6 different people. He kills his expected target, Nykris Ridley. But one of the other individuals he kills is Miriam Creighton, who's out that evening for a birthday celebration. She's shot in the back. The gunshots continue. As Nykris Ridley goes to the floor and is face down trying to get away, crawl away, the defendant keeps shooting. And he ends up, like as I mentioned, shooting 4 additional people. 6 total, 2 dead, 4 injured. Those other 4 were Donnell Laster, Laster, Taylor Holmes, Lauren Moore, and Isaiah Allen. My colleague is correct. I want to get into the criminal history in a minute, but my colleague is correct about one thing. This defendant does have friends in the community. Somehow, he was able to get a loaded handgun into this club, although he was frisked at the door. That's shown on video. The other thing, though, is that he has a friend, a very large, bulky guy, who pushed his way like a bulldozer through the chaos, through the crowd after the gunshots, and people are going crazy. He has a friend who bulldozed his way straight through to the exit, and the defendant was right behind him. This defendant would not have gotten out of that club so easily if he did not have this friend helping him get out of the club. There's one last detail I want to say before I get into the criminal history, and that is right before this defendant exited the club, he turns again and points his gun toward the crowd. Nykris Ridley is already down on the floor. His friends are already way back in the back of the club, but he continued to point his gun toward the crowd. This is not a self-defense case, and the identity issue is not so strong as my colleague would suggest, based upon the several different ways that he is identified, and plus he's clearly seen entering the club. So my colleague addressed several of the matters that are on the defendant's history, and I would like to first of all start with the Cobb County case, because my colleague is correct. That case did end up getting dismissed. So what we're talking about is Cobb County warrant number 21W2445. So this defendant on that case was booked in on March 25th of 2021, and he was released out on bond in that Cobb County case on March 28th of 2021. It was later dismissed about 2 years later on April 6th of 2023. But the reason why I mention it is that while this defendant was out on bond, he ended up getting arrested here in Fulton County. So he violated his Cobb County bond by getting arrested in Fulton County. And I would submit to the court that there's no bond order that's going to prevent him from going out and being charged, being arrested for additional felonies. The felony that he was arrested for here in Fulton County is now indicted as case number 22 SC 182559. And the court is correct in pointing out that this defendant actually missed court twice. So he missed court on August 23rd of 2022 for failure, and there was a judicial hold entered at that time for failure to appear. That judicial hold was then lifted, and the date of the order of the judicial hold was August 23rd of 2022. That's the date that he missed court and the date that that order was entered. That judicial hold was then lifted January 10th of 2023. So he got a second chance at coming to court. Even with his family support, whatever it may be, he had a difficult time finding his way to the courthouse a second time on March 13th of 2023, same case, he missed the arraignment again, and the court entered an order that same day, March 13th, 2023, for a judicial hold. And it's my understanding that as we sit here today, there's still a judicial hold outstanding in that case. So Mr. Reese has then gone on to commit other offenses. One offense that my colleague mentioned occurred on March 7th of this year, 2024. That case number is 24DA05368. And on that time, he was in a stolen Jeep together with others, and there was a police chase, and this defendant fled the police. The Jeep ended up getting wrecked. He and his friends abandoned that Jeep. What police located inside that stolen car were a total of 7 guns. One of them was stolen. The other 6 were there. And that case is still under investigation. He was not arrested that day. All that occurred March 7th of 2024. And then again, of course, this case occurred on May 12th of 2024. So while out on bond in the case that he has a bench warrant out for him, he ends up catching 2 different cases, March 7th of 2021, and then this case here, which occurred on May 12th of 2024. And so respectfully, we are going to ask that the court deny bond. I do have 3 individuals who would like to address the court if now is the appropriate time.
It is, thank you. And if you could either have them come to the podium or to the witness stand so that I can see and hear them.
Yes, Your Honor. I'd like to start with Dimitri Holmes. Ma'am, if you'll start by stating your name to the microphone and then spelling your name, please, for the court reporter.
Yes, my name is
Thank you, ma'am.
Dimitri. Thank you. My name is Dimitri Holmes, D-E-M-I-T-R-E-E, last name Holmes, H-O-L-M-E-S.
Okay. And then if
Go ahead when you're ready.
go ahead and make your statement.
Thank you for allowing me to have this platform. I am speaking on behalf of my Latasha Hall. She's my first cousin, and it was her grandson that perished in the incident. I stand before you today not only as a grieving family member, but also a representative of a life cruelty taken away. Leaving a 3-month-old baby. He was a father. This child is now fatherless and will grow up in an irreplaceable void, the void created by a senseless act of violence. My cousin's grandson was more than just a victim. He was a father, a son, and a cherished member of our family. His absence is a constant reminder of the defendant's heinous action. I urge the court to consider the gravity of this loss. Denying bond is a necessary step to ensure justice is served and that our community remains safe. Thank you, Your Honor, for considering our heartfelt plea during this difficult time.
Thank you, ma'am, and I'm very sorry for your family's loss.
Thank you.
Judge, may I be heard?
Mr. Kane, yes?
Yeah. With all due respect.
Do you wish to, well, forgive me, Mr. Kane, are you asking to examine the witness or?
I'm asking to be heard.
Okay.
Yes.
Okay.
With all due respect to the state's presentation and to Ms. Holmes, there's absolutely no authority for victim impact statements at a bond hearing. There's the IOLA factors, and this is not one of them. It's not relevant, and I'd ask the court to not receive any additional victim impact information at the bond hearing. Every crime has a victim, but it's not a relevant testimonial consideration for the court at this time. Thank you.
Understood, Mr. Kane. Mr. Griner, do you wish to respond to that?
Judge, the Victims' Bill of Rights and other principles allow them to make a statement to the court. It's proper. It's done routinely. And I understand that my colleague may not like what is being spoken. He, of course, has the ability to cross-examine if he wants to go down that road. But the victim's family absolutely has a right to be heard at a bond hearing, and also in its consideration of the different AL factors, which I will address at the close of the testimony.
So if there's authority, we'd ask the state to cite it, and I have never seen it addressed in an appellate decision, and then an IOLA or Burge, which preceded IOLA appellate decision. Never seen it. It's not relevant at this.
So, Mr. Kane, you have made your record. I've heard Mr. Griner's response. Let me say this. I think that you're both somewhat right in that I believe that based on the various laws that entitle victims to notice and an opportunity to communicate with the court about their feelings, et cetera, that they are entitled within reason to share with the court and provide some statement about their impact at this proceeding. Now, separately, Mr. Kane, you are right that it is the court's job to apply the necessary elements of IALA and to make sure that any decision that the court makes is based on those factors. But that doesn't mean I'm not going to hear victim impact statements that are being offered by the state. But your record has been made on that issue, and if you would like to revisit it further at a later time, you may do so. But for now, we're going to go forward.
I don't choose to repeat myself, and I do accept to the court's order.
Understood. Mr. Griner?
Next, we'll call Tracy Eason.
Your Honor and the people of the court.
Start by your name.
Okay, I'm sorry. Okay. My name is Tracy Eason, Tracey Eason. Your Honor and the people.
Go ahead.
Okay. Your Honor and the people of the court, I am here to speak on behalf of our beautiful daughter, Mari Creighton. She was a gentle soul, excluding kindness and humility, carrying herself as the young lady that I raised her to be. Each morning, I am reminded that I will never again receive her FaceTime calls. I will never be able to ask her what grade she received on her exam or how did volleyball practice go. She will not have the opportunity to walk across the stage and receive her baccalaureate degree from Albany State. Our planned graduation celebration to St. Croix will never happen. Instead, I was left planning her funeral. Mari was so very excited to finally be home from college as we were working on converting our basement to her very own apartment. Her summer plans to Texas and Florida this month will never happen. Mari will miss out on the simple joys of summer outings with loved ones, which began and tragically ended on Mother's Day. Mari was recognized as the golden child of my family. She had her very own nail salon in our garage. She had her very own sewing studio where she even crafted her own senior year prom dress. I will miss all of the creative noises in the house that came along with her many talents. My relationship with Mari was truly a bond that I can't simply describe with words unless you knew us. But what I can share with you here today is that my heart aches every single waking second of the day imagining what my baby must have gone through as she lay there alone, helpless, during the final moments of her life before she took her last breath. Gone are the nights when we would both say goodnight, I love you, and I love you too. Instead, I now stare at her pictures and watch videos until I can finally fall asleep. Mari, along with her entire village, and you can see here in pink, of loved ones, all received our life sentence on May 12th. She doesn't have a bond hearing here today to see if she'll be able to come home with us. Your Honor, my wishes are that the defendant does not receive bond. Thank you.
Thank you, ma'am. Again, I'm so sorry for your family's loss.
Thank you.
And thirdly, I'd like to call Taylor Holmes.
My name is Taylor Holmes, TaylorHolmes. Can I ask?
Go ahead when you're ready, ma'am.
Okay, I'm just waiting to so I can read it.
Okay.
I was filled with excitement at the thought of spending summer with Mari and also my other friends, enjoying our summer break, returning before our college campus. Little did I know my world would shatter on that fateful night of May 12th at 2:25. What was meant to be a joyous celebration of my birthday turned into a horrifying ordeal. Mari and I were caught in a crossfire, leaving me with physical and emotional scars that I may never heal from. The bullet still lodged in my leg. That is a constant reminder of the trauma I endured. Instead of embarking on summer adventures, I now find myself confined to physical therapy sessions and counseling sessions, struggle to remain normal. The loss of my mom, my auntie, my bestie, my girl, has left a void in my heart that will never be filled. As I stand here today, I plead for justice for the victims and for a chance to heal and to rebuild what was taken from us. My wishes are that the defendant does not receive a bond.
Thank you, ma'am.
So, Your Honor, clearly we oppose bond in this case. I would submit to the court that the defendant is a flight risk. He's fled from police before, trying to conduct traffic stops. No order of the court he's not going to obey any of that. He's also a threat or a danger to the community. If somebody's going to take a loaded gun inside a bar and shoot 6 people who are unarmed, is a definite threat to the community. He's also a risk of committing a felony pending trial. He's proven time and time again. My colleague is correct. There are no felony convictions at this point, but he has certainly committed felonies while out on bond. And I would also submit that I think that the matter was raised with my colleague. It's my understanding that deceased victim Nykris Ridley did know Karanji Reese, the defendant. There was some kind of relationship there, and so I would submit that that there may be a risk of intimidating witnesses. So I would submit to the court that bond should be denied on all 4 IALA factors and also under OCGA 1761E. Thank you, Your Honor.
Thank you, Mr. Griner. Mr. Connor, Mr. Kane, who will I hear from on behalf of the defendant in response? It's y'all's motion, so you will get the last word.
Your Honor, I just want to address one thing. My colleague says that my client, well, he named 2 witnesses that pointed to the description of my client, and he didn't specify the video footage that was shown to those witnesses. All right, so the video footage that was shown to the witnesses were outside the club. So they're putting my client at the club, but when the video footage was shown to the witnesses of the shooting inside the club, they could not determine if that was my client or not. That's all I have to say, Your Honor. I just wanted to point that and make that note for the record.
Thank you, Mr. Connor. So, I think Mr. Kane pointed out a moment ago, and Mr. Connor has mentioned it as well, that the relevant legal standard here is for the court to apply the Ayala factors, which generally we understand to be whether or not the defendant poses a danger to the community, whether the defendant is a risk of committing a felony pending trial, whether the defendant may intimidate witnesses or otherwise interfere with the administration of justice, and whether or not there's a concern that the defendant may not return for trial. I think that Mr. Connor correctly points out and reminds the court always that the presumption of innocence resides with Mr. Reese. I've heard a good bit from both sides about the facts of the case, but at the end of the day, I think that the appropriate way to apply the factors is to, number one, give the defendant the benefit of the presumption of innocence that he has, but also not to dig too deep into the facts of what are alleged, because that will come later in terms of what actually occurred in this case. So instead, what I am going to focus on are those Ayala factors. And what I see, as I pointed out to Mr. Connor during his presentation, is a history of a failure to appear. And Mr. Connor can, assert that it's a notice issue, but there's no indication given Mr. Reese's extensive ties to the community and fairly stable, it sounds like, family locations in the city or the county. I don't know anything about the notice issue in that case, but I'm not persuaded by it at this stage. So I will say that, and then beyond that, I also am concerned about the fact that while there were charges pending, Mr. Reese has continued to pick up new charges. And so because of that, I am concerned that Mr. Reese may not return for trial if he were released on bond. And I am also concerned that Mr. Reese poses a danger of committing a felony pending trial. And so for those 2 reasons, I am not going to grant bond at this time. Mr. Reese's motion for bond is denied. And I believe that concludes this matter unless there's any further record that anyone would like to make. Mr. Connor?
Nothing from the defense.
Thank you. Mr. Griner?
Nothing from the state. Thank you.
Okay. This matter is concluded. Mr. Reese may be excused.